Welcome to LexTalks Legal Topics, simplified your companion for exploring the fascinating world of law. Today,
Yeah.
we're diving into a topic that's particularly relevant for all you aspiring legal eagles out there,
Okay.
especially those of you in India.
Right.
We're going to be looking at the qualifications and disqualifications for becoming a member of parliament or a state legislature in India.
Oh, wow.
I've got to be honest.
Yeah.
When I first started reading through this, I felt a little lost.
A lot.
Luckily, we've got an expert here to help us navigate this complex world.
Absolutely happy to help break it down.
That's what I'm hoping for.
Yeah.
To guide us through this deep dive, we'll be using excerpts from legal texts like the Constitution of India and the Representation of the People Act, as well as a helpful document from the Election Commission of India. You can find that at ec.gov.in.
Great resource.
Now, let's start with the basics.
Sure.
What's the difference between qualifications and disqualifications?
Right.
I feel like these terms are often used interchangeably.
Yeah.
But there's a distinct legal difference, isn't there?
Absolutely. You're absolutely right.
Okay.
Qualifications are like the entry ticket.
Okay.
They're the positive attributes that make you eligible for a position.
Mm-hmm.
Think of it like applying for a driver's license. You need to be a certain age and pass a driving test.
Yeah.
Those are your qualifications.
Okay, that makes sense.
Yeah.
So what about disqualifications?
Disqualifications are the barriers that can prevent you from holding a position,
Right.
even if you meet all the qualifications.
Okay.
Going back to the driver's license example.
Mm-hmm.
Imagine you get your license.
Yep.
But then you get too many speeding tickets and it gets revoked.
Oh, right, yeah.
That's a disqualification.
Ah, so you might be qualified on paper, but certain actions or circumstances can disqualify you.
Yeah, exactly.
So in the context of becoming an MP or MLA, where do we find these qualifications and disqualifications?
The primary source is the Constitution of India. Articles 84 and 173 lay out the qualifications for members of parliament and state legislatures, respectively.
Okay, so those are our go-to articles.
Yeah.
And I noticed that citizenship is a big one.
Absolutely. Article 5 of the Constitution outlines how citizenship is granted in India.
Right.
And it's actually quite fascinating how it uses the phrase every person
Right.
when talking about those born in India on or after January 26, 1950.
That's interesting. Does that literally mean everyone? What about, say, someone born in prison, or even someone born to parents who were in the armed forces but stationed in India?
Yes, even they are included. It's meant to be a very inclusive definition.
Wow.
Now, once you've got your citizenship sorted, there's another crucial step, taking an oath or affirmation.
Yeah.
Articles 84A and 173A mention this.
Right. And I noticed from our election commission source that there are a whole bunch of officials authorized to administer this oath. So it seems like they've tried to make the process as accessible as possible.
Exactly. They've recognized that not everyone can easily get to a specific official.
Right.
So they've provided alternative options.
That makes sense.
Mm-hmm.
Now, what about age? Is there a minimum age to run for office?
Yes. The Representation of the People Act lays out the age requirements.
Okay.
For the Lok Sabha, you need to be at least 25 years old.
Okay.
And for state assemblies, it's 21.
Okay.
And in both cases, you need to be registered as an elector in a parliamentary constituency.
Hold on. Our notes also mention something specific about Sikkim.
Oh, right.
Is there something unique about their qualifications?
Sikkim does have specific qualifications related to certain reserved constituencies. For example, there are seats reserved for Sikkimese of Nepali origin and for scheduled castes.
Right.
These are in place to ensure representation for different communities within the state.
So it's important to be aware of those state-specific nuances.
Definitely.
Now let's move on to a topic that's been in the news a lot.
Sure.
The anti-defection law. It's also known as the 10th schedule to the Constitution, right?
It is.
Can you give us a quick overview of what it's all about?
The 10th schedule was introduced back in 1985.
Okay.
To address the issue of politicians switching parties after being elected, often for personal gain, the idea was to create stability in the political system while still allowing for legitimate party realignments.
That makes sense. But how do you differentiate between a legitimate realignment and just someone being opportunistic?
Right.
Isn't that a bit subjective?
That's where it gets tricky. The law has faced criticism for its ambiguity, particularly around terms like political party, split, and merger.
Right.
The lack of clear definitions has led to differing interpretations and even manipulation.
So it's a well-intentioned law, but potentially flawed in its execution.
That's one way to put it. We've seen instances where the law has been used to target political opponents rather than truly preventing unprincipled defections.
That sounds like it undermines the very purpose of the law.
It definitely raises concerns about fairness and transparency,
Yeah.
and it highlights the need for ongoing review and perhaps even amendments to strengthen the law and prevent its misuse.
Okay, so we've covered the basic qualifications and touched upon the anti-defection law,
Yeah,
but we've got a lot more ground to cover.
absolutely.
What are some other key disqualifications that our listeners, especially law students in India,
Right.
should be aware of?
One important one is the concept of office of profit.
Okay.
This disqualification is all about preventing conflicts of interest.
Right.
Essentially, it means that if you hold a position that gives you financial benefits from the government, you can't simultaneously be a member of parliament or a state legislature.
So it's about ensuring that your representatives are serving the people and not their own wallets.
Exactly.
But how do you determine what constitutes an office of profit?
Right.
That seems like a pretty gray area.
It can be, but luckily we have some legal precedents.
Okay.
That can help us understand how this disqualification has been applied in real-life situations.
Perfect. Let's delve into those case studies in the next part of our deep dive.
Sounds good.
We'll be right back after a short break.
Welcome back to LexTalks.
All right, so before the break, we were just starting to talk about the office of profit disqualification.
Yeah.
It sounds like a pretty important concept.
It really is, especially in a democracy where we want to make sure our elected representatives are working for the public good, not for their own personal gain.
Exactly.
Yeah.
But like we were saying, it's not always clear what constitutes an office of profit.
Right.
That's where case studies can be really helpful, right?
Absolutely. They give us real-world examples of how this disqualification has been interpreted by the courts.
Okay.
Let's start with a case that went all the way to the Supreme Court.
Okay.
This case involved a member of parliament who was also appointed as an auditor for two government companies.
That's interesting. So he was essentially holding two positions,
Yes.
one elected and one appointed.
Yes, and the question before the court was whether this auditing role counted as an office of profit. The court really had to analyze the details of his appointment and the level of control the government had over his work.
So was the source of his salary the deciding factor in this case? Could a teacher in a privately funded school, even with government aid, be eligible to run?
Those are great questions. In this particular case, the court found that the MP's auditing role did constitute an office of profit because he was appointed and could be dismissed by the government. Plus, his work and pay were directly controlled by the government, creating a potential conflict of interest with his role as an elected representative. Now, regarding the teacher scenario, it would depend on the specifics of their employment and the nature of the government aid. If the government directly pays their salary or has significant control over their work, it could potentially be considered an office of profit.
That makes sense. It's not just about the title, but the actual financial relationship with the government and the potential for influence.
Exactly. Let's look at another case this time involving a teacher. Okay. This case focused on whether an assistant teacher in a government-aided school was holding an office of profit.
So not a direct government employee, but still receiving government funding.
Right.
What did the court decide in this case?
Well, the teacher argued that he shouldn't be disqualified because he wasn't directly employed by the government. But the court ultimately decided that because his salary was paid by the government, even though it was through the aided school, his position did constitute an office of profit.
It seems like the courts are really focusing on the substance of the financial relationship, not just the technicalities of employment.
You're catching on. The overarching principle here is to prevent conflicts of interest and protect the integrity of the legislative process. Now, ready for one more case study?
Yeah.
This one involves a government contractor who wanted to run for the state legislative assembly.
Okay, this is the one where the status of the contract matters, right?
You got it. The key question was whether the contract was still active or if it had been completed.
So if the contract was still ongoing, he would be disqualified.
Exactly. The court found that a subsisting or ongoing contract could create a conflict of interest. But if the contract was finished and all obligations had been met, then the disqualification wouldn't apply.
That's a really important distinction.
Yeah.
So it's not a blanket disqualification for anyone who's ever had a government contract.
Precisely.
Yeah.
It's all about analyzing the specific circumstances and the potential for conflicts of interest.
These case studies have been really illuminating. I think they've helped to clarify what might have seemed like a very abstract legal concept.
I agree. Case studies are a great way to see how these laws are applied in practice.
Now, before we wrap up, I want to touch on the Election Commission's perspective on all of this.
Okay.
They play a huge role in ensuring free and fair elections, right?
Absolutely. And they've actually developed a risk matrix that highlights potential issues related to these qualifications and disqualifications.
Yeah, why?
They're particularly concerned about returning officers who are responsible for scrutinizing nominations, making incorrect decisions. This could lead to legal challenges and even the invalidation of election results.
Wow, that's a lot of pressure on those returning officers.
It is. That's why the Election Commission provides them with training and guidance to help them make informed and impartial decisions.
Okay.
But they also stress that the returning officers need to exercise their own independent judgment based on the facts of each case and the relevant laws.
So they have support, but ultimately the decision rests with them.
Exactly. The Election Commission recognizes that these decisions are not always easy or clear-cut.
Okay, so far we've covered a lot of ground. We've talked about the difference between qualifications and disqualifications, looked at specific examples from the Constitution and the Representation of the People Act, and even explored some case studies that show how these laws are interpreted in practice.
We've also touched on the Election Commission's role in overseeing this complex process and the challenges they face.
It's been a fascinating deep dive, but I feel like we've only just scratched the surface.
Oh.
What are some of the broader implications of these qualifications and disqualifications?
Right.
Do they strike the right balance between ensuring qualified representatives and preventing unfair exclusion?
That's the million-dollar question, isn't it? And it's one that legal scholars and policymakers continue to debate.
Yeah.
On the one hand, we need these rules to maintain the integrity of our elections and prevent conflicts of interest.
Right.
But on the other hand, we need to be careful that these rules aren't used to unfairly target individuals or groups and limit their participation in the political process.
So it's a delicate balance.
Exactly. It requires constant scrutiny and a willingness to adapt and refine these laws as needed to ensure they're serving their intended purpose fairly and effectively.
All right, I think we've covered a lot of ground in this deep dive. In the next part, we'll wrap things up and leave our listeners with some final thoughts and perhaps some questions to ponder. Welcome back to LexTalks.
Back for the final stretch of our deep dive.
We're diving deep into those qualifications and disqualifications.
Right, for those who want to be members of parliament or state legislatures.
In India,
Of course, in India.
we've covered a lot.
We have from the constitutional provisions to those case studies.
We even touched on the Election Commission.
Yeah, their role in all of this.
But I want to circle back to something
Okay,
before we wrap up.
sure.
The misuse of these disqualifications.
Right. You're right to bring that up. It's a valid concern.
We talked about that ambiguity
Yeah.
in the anti-defection law
Mm-hmm.
and how someone could manipulate that.
Absolutely.
And even the Office of Profit disqualification,
Right.
meant to prevent conflicts of interest,
Mm-hmm.
but it could be used unfairly.
Yeah. Against political opponents.
Any law
Any law, no matter how well-intentioned,
can be misused.
yeah, misused or misinterpreted. Yeah.
Exactly. And when it comes to elections,
Right.
transparency and accountability,
They're so important.
they're paramount.
Yeah. Couldn't agree more. The way these disqualifications are applied, it can have a big impact
Huge impact.
on the fairness and integrity of our elections.
So what can we do?
Well, the Election Commission is trying to provide some guidance and training to those returning officers.
Yeah.
And that's definitely a step in the right direction. Emphasizing their independent judgment is crucial.
So they know the potential problems.
Yes, they do.
And they're trying to fix it.
Yeah, they
Oh,
are.
it's not a static system.
Right.
It's always evolving
It is constantly evolved
to make things more fair.
to meet those challenges, for sure.
This has been eye-opening.
It has.
So much complexity.
Under the surface.
Yeah.
It's amazing how much is there to these straightforward rules.
For our listeners,
Especially those law students in India.
yes, especially them,
Right.
I hope this sparks some curiosity
Yeah.
about this area of the law.
I hope so too. It's fascinating.
Question those assumptions.
Yeah.
Look into those case studies.
Really grapple with it.
Yeah.
Legal reasoning behind these provisions.
Because we need to understand how our elections work
Right.
so we can participate.
In a more just and democratic society.
Well said. Knowledge is power,
It really is.
especially in the legal world.
Especially in the legal landscape. Yes.
Thank you to our experts
It's been my pleasure.
for guiding us through this,
Yeah.
and to our listeners for joining us.
It's been great to have you all.
Thank you for listening to LexTalks.
That's it for us.
Follow, subscribe, and stay notified to never miss an episode.